This month we'll be talking about two talking chairs. I love the title because I'm the current chair of the Law Society Wills and Equity Committee, and I'll be talking to Ian Bond, who was a former chair of the Law Society Wills and Equity Committee. And this month we'll be talking about problems when people try and stop the administration of an estate, for example after registering a caveat, and we'll be finding underused solutions for you. The next thing we want to talk about is the heartbeat of the common law spouse. As lawyers, we're always saying there's no such thing as a common law spouse, but the Labour Party in its last manifesto said that it wanted to enhance rights of women and put those rights at the heart of their missions. And so I've been involved in a consultation this month with senior officials who advise government ministers about how they can implement changes to the intestacy rules for the benefit of cohabitees. I'll be explaining that in more detail, and I'll also be looking at the outcome of the SRA thematic review into probate lawyers, and we'll be talking about how their conclusions can benefit your practice. I want to talk about one of the issues that people we work with tell us is a real issue for practitioners. That's what happens when there's a caveat and you're stopped from dealing with the administration of the estate. Now, firstly, there's over 10,000 caveats a year being registered. So that can cause enormous disruption to the administration of an estate and can cause enormous frustration because, of course, it stops you getting a grant of probate. So this month I'll be having a conversation with Ian Bond about how we can solve those problems. Well, the first problem, of course, is to do nothing. We don't really see that as an appropriate solution because all sorts of problems can arise if you decide to do nothing. I mean, property in an estate can get vandalized or damaged. Premium bonds stop attracting prizes after 12 months. The value of shares can go down. Companies who've got estate assets can go insolvent if you leave things outstanding. And so to do nothing, in our view, is always a risk for practitioners. And we see problems when that happens and we take action against executors. So my firm advice would not be to do nothing. The second aspect, if you like, is to attack the caveat. Now, it's easy for people to register a caveat, but it's equally easy to serve an appearance to try and warn off the caveat. Sorry, to serve a warning to warn off the caveat. But then it's easy to register an appearance. And once an appearance is registered, that makes the caveat permanent. A caveat or may fall by the wayside and may let a caveat lapse inadvertently, but most people who register caveats are pretty switched on, so it's not usually a good tactic just to wait. But there's another way to attack the caveat, which is being done more frequently, and I quite like the quaint expression of getting a put up or shut up order. And basically what you can do is go to the probate registry and say, look, these people have registered a caveat, but they've not done anything. They've not challenged the will. They've not issued legal proceedings. So make a put up or shut up order. And when that happens, the probate registry will make an order that says to a caveat, all right, we've seen what you've done. You've not progressed it. You've got 28 days. That's typically 28 days to start court proceedings and get them served, or else your caveat will be dismissed. So a put up or shut up application, the probate registry, is actually quite a useful tool. It's an underused tool and people don't do it enough. So if there's a problem, you can come to us and talk to us about that, and we'll discuss how we can make progress. The other way that is also underused is to get a grant ad collegenda bona. I find it interesting that since about the year 2000, it's been the policy of successive governments to say Latin has no place in court proceedings anymore. It's all about plain English. But phrases like this, a grant ad collegenda bona, remain. And it just means it's a collection grant. You're entitled to collect the to collect the estate assets, but not distribute them. And the other thing that I find quite interesting is that it's what you call a common law invention. It goes back to the court of Henry VIII. Some parts of the probate process are enshrined in legislation, in the Senior Courts Act. For example, you can get a grant pending litigation outcome, and that's referred to in the Senior Courts Act. But the grant ad colligenda bona is a common law invention. There's good news and bad news about it, because although we think it's underused and people should use it more, the process is actually quite complex and quite cumbersome. And because it's not a statutory process, there's sometimes misunderstandings about when it can be used. For example, a probate registry will sometimes take the view that you can only get a grant ad colligenda bona if there is a danger, and that's a word that they use, a danger to the estate. Well, I've already said, in my view, there's always an inherent danger if people don't get on and administer an estate, because our property can get vandalised, insurance premiums increase, a company can go into insolvency and all the rest of it, right? So it's my view that there's often an inherent danger. And being cynical about it, if you get a grant ad colligenda bona, there's more work, but it gives you control of the estate administration. There's more work that you can get paid for, and it makes progress in an estate that would otherwise be frozen. So again, the procedure is quite cumbersome. If you've got problems with the procedure, then talk to us or send us an email. We've been encouraging people to make applications for grants ad colligenda bona, and that people have been getting a lot of success with it, and it's unlocking the administration of an estate. So don't do nothing. Give us a call or send us an email. As lawyers, we're forever going around trying to disabuse people of the notion that there's no such thing as a common law spouse. But I'm here to tell you that the heartbeat of the common law spouse is growing stronger, because in 2013, the Law Commission did a consultation and concluded that the rights of cohabitees should be increased in intestacy situations. Now, the then government that received the Law Commission report decided not to do anything with it. But the Labour Party is now in power, and I don't suppose many people will have read the Labour Party manifesto, but I have, as part of my preparation for this talk to you today. And the Labour Party put in their manifesto that they wanted to strengthen the rights of women, and they wanted to put women's interests at the heart of their missions in government. And so recently, the Labour Party has brought back and revived the concept of the common law spouse, and is trying to give, I'll call them a common law spouse or cohabitee, the same rights as a married person. So I've had a meeting recently with senior officials at the Ministry of Justice. They're the officials that report directly to government ministers, so we know that this is on the agenda. And basically what the government wants to do is amend the intestacy rules so that a qualifying cohabitee would get the same rights on intestacy as a spouse. So that's why I said at the beginning the heartbeat of the common law spouse is growing stronger. Now, to be a qualifying cohabitee, what they propose is that if you've been living together for 5 years, then you automatically qualify in an intestacy. So that means you would inherit your spouse's share, the same share as a wife or husband. But if you've got a child together, that qualifying period would be reduced from 5 years to 2 years. So these proposals are likely to be wheeled out first. We always say that at IDR Intel, we want to give you the insight of things that are happening behind the scenes before they actually happen. So it's not our role to say, as advisors to the government, look, this is a good thing or a bad thing. Government is elected, government has the power to do what it wants. But where we're called in is to show some of the problems. And one of the immediate frustrations that I'm sure you will have clocked, that it's all well and good saying as a government that you want to give cohabitees the same rights, but the government apparently has no proposals to change the tax legislation so that, for example, in an inheritance tax situation, a spouse will get the estate transferred free, but a cohabitee won't. So that means that if a cohabitee is living in an expensive house that they inherit from their partner, then they will have to pay inheritance tax potentially on that and might have to sell the family home anyway to pay the inheritance tax. So being a little bit cynical, that's a problem that they don't seem to have thought about. The other thing is, of course, that there's no documents. It's not a documented process. If you've got a marriage, then you can turn up with a marriage certificate and say, look, we are married. But often when people start living together, it's not an immediately apparent date, particularly often with older people, that they might both have a house each and they might start spending a few nights in one house, then a few nights in the other house. And that could go on for a couple of years and they spend a few nights apart. And then they decide perhaps to actually start living together, maybe sell both properties and buy a new one. But how do you define the exact start date when people are not just sort of going out together, but are living together and husband and wife, which is the sort of the key criteria, or as spouses? So we've got a problem with documents. And the other thing, of course, is that it only affects intestacy. So that if one party goes and makes a will and says, I leave everything to the cat's home, well, at the moment, a cohabitee would have the right to make a claim for reasonable provision under the Inheritance Provision for Family Independence Act of 1975. But the government has as yet produced no proposals to reform the inheritance provision legislation. Now, just supposing you've got two partners who've both got modest means, as I've said, they might both have an income. Well, under the Inheritance Act, you're only entitled to reasonable provision limited for your maintenance if you are a cohabitee, whereas a spouse has a right for reasonable provision, which is not just limited to maintenance. And so that's another one of the problem areas, because if the Labour Party only tackle one small bit of it, intestacy, what you might find out is that more people are making wills, leaving everything to children by a previous relationship, and the partner then has limited right to make a claim. So these are issues that we've flagged up to the government and we've said, look, you need to have a comprehensive review. You can't just tackle things on a piecemeal basis. If you're going to change the law about rights, then please give further thought to making everything harmonised. So that's our view, that's our insight. We think that this will be brought forward when government has appropriate time to do so. And that's when you end up in the political arena, because all sorts of things happened with world or domestic events which can derail timescales. So there we are. The common law spouse has a heartbeat. The SRA has just produced what it calls a thematic review into the work of probate and private client lawyers. I always find it interesting that the SRA seem to have a language of their own. They like calling things thematic reviews, but that's not language that people use in day-to-day conversation. Anyway, they've done an investigation. They've gone and done interviews and they've attended the offices of 25 firms, all sorts of shapes and sizes, large firms, small firms, etc., who do at least 10% of their work in private clients. So they've gone and interviewed lawyers in their offices. They've also done a survey of a few hundred lawyers to find out about what they do. And the SRA thematic review is available on the SRA website, so you can find the detail if you want it. But it's been received in quite negative terms because they've been saying that they found that there was poor control of money laundering, that people didn't use the SRA website enough to obtain information, and that people only tended to look when there was a problem. So I would encourage everybody, in fairness, we all need to be up to date. It's probably one of the most boring bits of our job, but we have to be up to date with money laundering and with client identification and potential terrorism, because an attack on any of us can come from anywhere, perhaps when we least expect it. So the SRA is right to raise concerns. We all need to embark on continuous improvement. But in my job, I go around the country, I do lectures, I do webinars, I sit, as you know, on the Law Society Wills and Equity Committee, and I find nothing but the highest quality work from the vast majority of people who engage in this area of work. And indeed, the fact that you're giving up your time to listen to me now shows your dedication and your expertise, because it'd be easier to switch off and not watch me, all right? So do make sure that you record your time spent on these webinars so that you can demonstrate that you are interested and alive to the issues, the professional conduct issues that arise. But I would rather take quite a few positives from the SRA thematic review, which probably didn't get enough attention, because the SRA have concluded that the SRA have concluded in the majority of cases, members of the profession are meeting the needs of clients in difficult circumstances, particularly the needs of vulnerable clients. So if ever you need clauses or paragraphs of commendation from the SRA, take not the negatives, but the positives, and rely on their examples of good practice that they found, and the fact that people do embark on continuous training and continuous improvement. So have a look at the report, don't be downcast, champion and celebrate the achievements that we make and the expertise that we have as private client practitioners. It's a fantastic area of work to be in. Thanks for watching.